issued by the High Court, and unless the appellate court dispenses with the filing of the decree or judgment or both for the time being, the decree drawn pursuant to the said judgment. This is an amendment with regard to presentation of appeal. In 41 Rule 2, there are no amendments. Rule 3A, there are no amendments. Rule 4, no amendments. Rule 5, relating to Rule 5, relating to stay by appellate court and also stay by trial court. If you are having the book relating to these amendments, then you will note that Andhra Pradesh has adopted the amendments of Madras, High Court amendments. We have to add the following to the sub-rule 1. And may, when the appeal is against a preliminary decree, stay the making of a final decree in pursuance of the preliminary decree or the execution of any such final decree if already made. That is the state amendment with regard to sub-rule 1 and sub-rule 1 of Rule 5 after the words, but the appellate court may sufficient cause order stay of execution on such terms as and conditions as the court deems fit. That is added as per the amendment. Now, sub-rule 3 will not touch it. Sub-rule 5. Is omitted in the Madras High Court amendment, which is adopted by Andhra Pradesh. And then Rule 6, 8, there are no amendments. 9, there are no amendments. 10, there are no amendments. 11, 12. But we have a very 11, 12, 13, there are no state amendments. Rule 14. Proviso to sub-rule 1 is added. Order 14, Rule 1 speaks about service of summons. Now, this amendment is provided that the appellate court may dispense with the service of notice on respondents against whom the suit has proceeded ex parte in the court from whose decree the appeal is preferred. Therefore, you need not serve notice on the defendants who remained ex parte in the trial court when you file an appeal. That's why this amendment is important and it will be of use when there are a number of defendants and some of them have remained ex parte. And then let us go to Order 14, Clause 2. Sub-rule 2. Instead of sending the notice to the court from whose decree The appeal is preferred. Appellate court may itself cause a notice to serve on the respondent or his pleader under the provisions above referred to. And 3, the notice to be served on the respondent shall be accompanied by a copy of the memorandum of appeal. Notwithstanding anything to the contrary contained in sub-rule 1, it shall not be necessary to serve notice of any proceeding incidental to an appeal on any respondent other than a person pleaded for the first time in the appellate court, unless he appeared and filed an address for service in the court of first instance or has appeared in the appeal. Therefore, if there is any incidental proceeding which is launched in the appeal, which is filed in the appeal, then notice should be given to only a person who has appeared and filed an address for service in the court of the first instance. And then nothing in sub-rule 4 shall bar the respondent referred to in the appeal from defending it. Therefore, even if he is not given notice, he can appear and defend in the appeal. Order 15, 41 rule 15 is omitted. So 16, right to begin. On the day fixed or any other day to which the hearing may be adjourned, appellant shall be heard in support of the appeal. The court shall then, if it does not dismiss the appeal at once, hear the respondent against the appeal, and in such case, the appellant shall be entitled to reply. Here again, after hearing the appellant, the court may dismiss the appeal. And then dismissal of appeal for appellant's default. Where on the day fixed or on any other day to which the hearing may be adjourned, the appellant does not appear when the appeal is called on for hearing. Court may make an order that the appeal be dismissed. Nothing in this sub-rule shall be construed as empowering the court to dismiss the appeal on merits. The explanation is very clear. When the appellant does not appear, only a default order has to be passed. But in the absence of appellant, the court cannot decide the matter on merits. Where the appellant appears and the respondent does not appear, the appeal shall be heard ex parte. Then 18 is omitted. 19 is readmission of appeal dismissed for default. Where an appeal is dismissed under Rule 11, Sub-Rule 2 or Rule 17, the appellant may apply to the court for readmission of the appeal, and where it is proved that he was prevented by any sufficient cause, and the appeal is called and or from departing the sum so required, the court shall readmit the appeal on such terms. So therefore, when the appeal is dismissed for default, it can be again restored under Order 41 Rule 19. And as per the state amendment, the provisions of Section 5 Limitation Act shall apply to application under Sub-Rule 1. Therefore, delay condonation is available. And then power to adjourn hearing and direct persons appearing interested to be made respondents. Where it appears to the court at the hearing that any person who was a party to the suit in the court from whose decree the appeal is preferred, but who has not been made a party to appeal, is interested in the result of the appeal, the court may adjourn the hearing to a future date to be fixed by the court and direct that such person be made a respondent. No respondent shall be added in this rule after the expiry of the period of limitation for appeal, unless the court, for reasons to be recorded, allows that to be done on such terms as to pass as it thinks fit. So, the appellate court may direct the appellant to add all those persons interested in the appeal who appeared in the trial court. However, no respondent shall be added after the expiry of the period of limitation for appeal, unless the court allows to do so. Then rehearing on application of respondent against whom ex parte decree is made. This is also very simple. Either he is served or not duly served or prevented by sufficient cause, then he can appear and file a petition to set aside the ex parte order passed against him and participate in the hearing of the appeal. And then 22, upon hearing, respondent may object to decree as if he had preferred a separate appeal. This is important. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor, and may also take any cross objection. So the respondent in the appeal is not having a grievance against the entire appeal. The matter may have gone in his favor, but with regard to one of the issues, he wants to object. Then he may file a cross objection, which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for, or within such further time as the appellate court may see to allow. And then explanation, a respondent aggrieved by a finding of the court in the judgment on which a decree appealed against his based may, under this rule, file cross objection in respect of the decree insofar as it is based on that finding. Notwithstanding that by reason of the decision of the court on any other finding which is sufficient for the decision suit, the decree is wholly or in part in favor of that respondent. Therefore, cross objection can be filed even if the case of the respondent was accepted in the trial court. And the suit was decreed wholly or in part. In the form of objection and provisions applicable thereto. Such cross objection shall be in the form of memorandum and the provisions of Rule 1 so far as they relate to the form and contents of the memorandum of appeal shall apply thereto. So that is this saying the same way appeal is to be filed, then cross objection to be filed. Then in any case in which the respondent has under this rule filed a memorandum of objection, the original appeal is withdrawn or is dismissed for default. The objection so filed may nevertheless be heard and determined after such notice to the other parties as the court thinks fit. So even if the appellant does not turn up, the cross objection will be heard. The provisions relating to appeals by indigent persons are so far as they can be made applicable, applied to an objection under this. Therefore, somebody may also come under 33 CPC as an indigent person and file cross objection. And then remand of case by appellate court. From here onwards, I request you to concentrate on the powers of the appellate court and the options before it, depending on the deficiency in the judgment of the trial court or the errors committed by it or omissions with regard to giving a finding. And order 41 Rule 23, there is High Court amendment, which is akin to that of Madras, which is adopted from Madras High Court. Where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct that what issue or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, with the directions to readmit the suit under its original number in the register of civil suits and proceed to determine the suit and the evidence, if any, recorded during the original trial, subject to all such objections, the evidence during the trial after remand. Therefore, this is a remand in which the trial court has disposed of the suit on a preliminary point. And such a decree is reversed in appeal, then what the appellate court has to do is stated. Then the appellate court will direct what issues have to be tried. And already the evidence recorded will be part of the evidence in the suit. And then what does the Madras Amendment say? We please go to the second line in Order 41, Rule 23. And the decree is reversed in appeal. Then after these words, or where the appellate court in reversing or setting aside the decree under appeal considers it necessary in the interest of justice to remand the case. So this is one more option for the appellate court. Just in the interest of justice, they may remand the case. Apart from remanding the case, to take evidence on all the issues as directed by it. And then 23 cap,
1908.
yes, capital 23 capital A. Where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed in appeal and a retrial is considered necessary, appellate court shall have the same powers as it has under Rule 20. Rule 23A pertains to a particular situation. The appellate court has reversed the judgment of the trial court on a preliminary point. But a retrial is considered necessary. Therefore, appellate court shall have the same powers as it has under Rule 23. In Rule 23, the appellate court will only direct what issue or issues shall be tried in the case so remanded. But in 23A, it may order for a retrial. (24) Where evidence on record sufficient, appellate court may determine case further. Therefore, 24 is the stage which is reached if there is no necessity to invoke 23 or 23A. Where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment, the appellate court may, after resettling the issues if necessary, finally determine the suit, and notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than that on which the appellate court proceeds. Therefore, where evidence on record is sufficient and shall determine the appeal, if there is necessity of resettling the issues, but if the evidence on record is sufficient, then the appellate court may resettle the issues and finally dispose of the appeal. The appellate court may proceed on grounds which were not considered by the trial court. That is the last part of the section. (25) Where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine a question of fact which appears to the appellate court essential to the right decision of the suit upon the merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred. In such case shall direct such court to take the additional evidence required. This is another contingency. Appellate court may frame issues and refer them for trial to court whose decree is appealed from. In 24, what happens is the evidence on record is sufficient, issues may be resettled, but all the same appeal is disposed of. Here, appellate court will frame issues and refer them for trial to court whose decree appealed from. Please see the words. Appellate court thinks that it is essential to the right decision of the suit upon merits. And if the trial court has omitted to frame or try an issue or determine any, there are three things. Omitted to frame an issue or omitted to try an issue or to determine any question of fact. That's all. So all these three you have to see the judgment of the trial court with regard to all these three aspects. Was there an omission to frame issue or try an issue or determine any question of fact? So if any of these three are present, and if you think that the lower court judgment suffers from any of these infirmities, then you can invoke Order 41, Rule 25 when you argue the appeal. You have to frame the arguments in appeal depending on what happened in the trial court. What is the judgment? Whether any of these things have really occurred. Therefore, then the appellate court may frame issues if necessary and refer the same from whose end in such case shall direct such court to take the additional evidence required. When another issue is framed, then the court will direct additional evidence to be taken. And such court shall proceed to try such issues and shall return the evidence to the appellate court together with its findings thereon and the reasons therefore within such time as may be fixed by the appellate court or extended by it from time to time. Then the trial court will take evidence and return the evidence to the appellate together with its findings. And the reasons therefore within the time fixed by the appellate court are extended from time to time. Therefore, this is a particular situation depending on the infirmities in the judgment of the trial court, where you think the trial court has omitted to frame an issue or try any issue or determine any question of fact. This generally occurs when 3 or 4 issues are discussed together and decided. Therefore, read the judgment of the trial court if you are filing an appeal to find out if there is anything which attracts the provisions of Order 41 Rule 25 CPC. And then 26, findings and evidence to be put on record, objections to finding. Such evidence and findings shall form part of the record in the suit, and either party may, within a time fixed by the appellate court, present a memorandum of objections to any finding. Determination of appeal. After the expiration of the period so fixed for presenting and make such memorandum, the appellate court shall proceed to determine the appeal. Now, what happened under Order 41 Rule 25? Appellate court has directed the trial court to record additional evidence with regard to trying the issues framed by it, and additional evidence is taken, finding is given. Now, before the appellate court, there is an additional finding of the trial court, which was not part of the original judgment. Therefore, such evidence and findings shall form part of the record, and either party may, within the time to be fixed by the appellate court, present a memorandum of objections to any finding. After the expiration of period so fixed, the appellate court. So now there is another finding. Either the appellant or the respondent may have an objection to such finding. Therefore, the court will give them time for filing objections, and then if objections are filed or if they are not filed within the time given, then the appellate court will determine the appeal. (26A). If an order of remand is passed, you can request the appellate court to fix a date for the parties to appear before the trial court. Order of remand to mention date of next hearing. Then production of evidence, additional evidence in appellate court. As I told you, unless you take thorough instructions and file all documents in the trial court, there may be instances where you may have to file additional evidence in the appellate court. But in spite of due diligence exercised by the party and also the advocate, there may be occasions where additional evidence may be available and it has to be filed before the appellate court. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. First thing is, they are not basically entitled to adduce any additional evidence. There is no such vested right. But if the court from whose the decree the trial appeal is preferred has refused to admit evidence which ought to have been admitted, or the party seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge. First point. This additional evidence was not within the knowledge of the appellant, or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. There are two aspects. It was not within his knowledge, that is one situation. But he could not, the next situation is he could not produce it before the trial court, even though he exercised due diligence. And then the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. court itself may require any document to produce on any witness to be examined to enable it to produce the pronounced judgment. This is with regard to additional evidence. The appellate court may allow such evidence or document to produce or witness to be examined. Whenever additional evidence is allowed to produce by an appellate court, the court shall record the reason for its admission. So as per the case law, the petition filed by the appellant under Order 41 Rule 27 will not be decided separately. It will be decided along with the appeal. Then because additional evidence is ordered to be taken, the appellate court will pass appropriate orders with regard to taking of additional evidence. That is about Order 41 Rule 27. You have got a lot of case law on Order 41 Rule 27. This is a provision which is often resorted to in the appeal. And then 28, mode of taking additional evidence. The appellate court may either take such evidence or direct from whose decree the appeal is preferred or any other subordinate court to take such evidence and to send it, then take it to the appellate court. Points to be defined and recorded. Where additional evidence is directed or allowed to be taken, the appellate court shall specify the points to which the evidence is confined and record on its proceedings the points so specified. So the appellate court will allow additional evidence only on such points which it considers necessary. Judgment when and where pronounced, either in the open court or either at once or on some future day. Court need not read out the entire judgment. That is the purport of Order 41 Rule 30. It pertains to the obligations of the appellate court. And then 31, contents, date, and signature of judgment. Judgment of the appellate court shall be in writing and shall state the points for determination, decision thereon, the reasons for the decision, and where the decree appealed from is reversed or where the relief to which the appellant is entitled. So, in the trial court, there will be issues and each issue will be dealt with. Now, after all the steps so far discussed have been exhausted and the appellate court has to deliver a judgment, then it will frame points for consideration. They are not issues, but trial court will, after going through judgment, will frame points for consideration. The decision thereon, reasons for the decision, and if decree is reversed or varied, the relief to which the appellant is entitled. So this is the manner in which an appeal is disposed of by the appellate court. And on this aspect, there is Madras High Court amendment which is adopted by Andhra Pradesh. It is only bear the date on which it is pronounced and shall be signed by judges or the judges concurring therein. Provided that where the presiding judge is specially empowered by the High Court to pronounce his judgment by dictation shorthand written in open court, the transcript of the judgment so pronounced shall after such revision has been deemed necessary be signed by the judge. So if the judgment is declared in the dictated in the open court, that is also allowed. And then 32, what judgment may direct? The judgment may be for confirming, varying, or reversing the decree from which the appeal is preferred, or if the parties to the appeal agree as to the form which the decree in appeal shall take, or as to the order to be made in appeal, the appellate court may pass a decree or make an order accordingly. So ultimately, the appellate court may confirm the judgment, vary it, or reversing the decree from which the appeal is preferred, or if the parties to the appeal agree as to the form which the decree in appeal shall be taken, or as to the order to be made appeal, appellate court may pass a decree or make an order accordingly. The parties to the appeal agree to the confirming, varying, or reversing the decree, then the court may make such a decree. And then power of appellate court, Article 41, Rule 33. The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as part only of the decree and may be exercised in favor of all or any of the respondents or parties. Although such respondents or parties may not have filed any appeal or objection, and may where there have been decrees in cross suits, or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees. Provided the appellate court shall not make any order under 35A in pursuance of any objection of the court from whose decree is appeal has omitted or refused to make such order. So barring 35A with regard to compensatory costs, then this is where the power of the appellate court is to be urged to be exercised by the appellant or the respondent, as the case may be. Because you see the powers of the appellate court. He shall have power to pass any decree and make any order which ought to have been passed, or made, and to pass or make such further or other decree ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may where there have been decrees in cross suits, or two or more decrees are passed in one suit, to be exercised in respect of all of any of the decrees, although an appeal may not have been filed. So therefore, the appellate court has got all the powers to do substantial justice between the parties, even if they don't file objections, even if they don't have objection to the decree. Then the court will look at what ought to have been passed in the trial court or made, then it will pass such orders. There is an illustration. A claims a sum of money due to him from X or Y, and in a suit against both, obtains a decree against X. X appeals and A and Y are respondents. The appellate court decides in favor of X. It has the power to pass a decree against Y. So the claim of A is against X or Y. Trial court decreed suit only against X. When appeal comes, the appellate court may say that A is entitled to a decree not from X but from Y, because both are there as respondents. A and Y are respondents in the appeal. So this is the illustration which will give you an idea as to the powers of the appellate court. You please note one judgment. New India Assurance Company Limited versus M. Prabhu. New India Assurance Company Limited versus M. Prabhu, reported in 2012 Accident Claims Journal 2391. Judgment of the Karnataka High Court. This is a case of motor accident claim. Claimant did not appeal for enhancement of compensation, but appellate court has got power to enhance the compensation. And suppose 34 relates to where dissent is to be recorded, where appeal is heard by more than one judge. Certified date and contents of decree. See, clear specification of the relief granted or other adjudication made. And then copies of judgment and decree to be furnished to parties at their expense. And then certified copy of decree to be sent to court, to the trial court. Or in case it is second appellate court, to the first appellate court. So these are the provisions relating to appeals. Because for 2 days I have spoken about appeals. I think I did not find many advocates who are handling appeals, but all the same, I request you to clear your doubts, if any. Sridhar garu. If you have any doubts, please మేడం కొంచెం అన్మ్యూట్ చేయండి ఎవరైనా డౌట్స్ అడుగుతారని.
Now you can unmute yourselves.
Sir, good morning, sir. Namaste, sir. Sir, Sir, regarding the
Remember?
appeal, civil appeal, sir, it's a
ఎవరికైనా
dismissal for a
మిక్స్డ్
default.
మిక్స్డ్
Default,
కేసులు ఎవరికైనా ఉంటే చెప్పావా
sir,
One
ఆహా,
at a time,
mixed.
one at a time.
sir,
మేడం అనితా మాత్ర గారు చెప్పండి.
sir,
మిక్సింగ్
sir,
ఉన్నాయి.
ఒక appeal case అంటే మేము
నేను 4 పీసులు
10 years
లెక్కలు
was
ఇచ్చేస్తా నువ్వు ఎంత ఇచ్చుకో
dismissed for default.
One at a time, one at a time, please.
ఉన్నాయి ఒక 40-50 పీసులు అంటే
నరేష్ రెడ్డి గారు ప్లీజ్ వెయిట్ ఫర్ ఎ వైల్.
Madam Anita, madam, please.
Sir, ఒక suit, sir, it was dismissed for default, sir.
Yes.
It was already 15 years ago. నాకు 10 years అయిన తర్వాత నా దగ్గరకు వచ్చిందండి. ఇక లిమిటేషన్ పీరియడ్ ఫర్ అపీల్ ఇస్ ఆల్సో అని చెప్పారు. బట్ ఈస్ దేర్ ఎనీ స్కోప్ ఫర్ అగైన్ అపీలింగ్, సార్? అంటే ఇట్స్ ఎ కొల్యూషన్ బిట్వీన్ 2 advocates. సో నాన్ అపీరెన్స్ aspect
Who is aggrieved by the judgment?
defendant, no, plaintiff, sir. Plaintiff.
Or any third party?
No. It's a suit for partition, sir.
Yes.
It was a dispute in this particular matter.
What happened to the final decree?
It was dismissed on non-appearance of the parties and not appearing of the
Final decree.
Final decree. Plaintiff advocate also did not appear before the honorable court, and he was not. Plaintiff is an illiterate. He was not given proper instruction. Totally, the decree was dismissed. Ex parte ఇచ్చేసారు. But it was later dates lo em tesilandi qualified matter. So can we again appeal, sir?
No, you can file with delay condemnation.
It's a long period kadandi.
You have to give reasons.
Yes.
Court may not agree, but you have to make an effort. That's all.
Yes. Effort. Ante. Thank you, sir. Thank you.
Yes. Yes. Yes, please go on.
Sir, good morning, sir.
Good morning.
Sir, in one declaratory suit,
Yes.
there is a slight difference between decree and judgment, sir. It was given in 2019.
Yes.
It was given in favor of the plaintiff,
Yes.
but defendant filed appeal. He also filed IA for stay. Stay was not granted, sir.
Yeah.
Till it is continuing. Now
Yes.
he is raising that point. There is a slight difference. It is infructuous. Whether it is infructuous, sir, or any rectification is there in that.
So if you think that there is some error in the decree, you can argue in the appeal. Nothing wrong. As I told you, 4133 says, order
sir.
which ought to have been made.
Yes, sir.
But the appellate court has got every power to rectify that.
Thank you, sir. Thank you very much, sir.
Yes. Yes. Shall I close for today? There are no.
నిజానికి ఇంకొంచెం టైం కావాలేమో వాళ్ళకి ప్రిపేర్ అవటానికి.
Second thing is,
Yes, sir.
whether it is during the suit or during the appeal, if there are any subsequent events, the Supreme Court said they should be brought to the notice of the court and they should and the court will take into consideration subsequent events while giving the relief. Yes.
And by way of additional,
No,
additional,
subsequent events have to be brought to the notice of the court.
how,
By filing a petition. After the suit is decreed for eviction of the vacant site, defendant has made some temporary construction or whatever it is. Whatever subsequent event that takes place with regard to the property, then it has to be brought to the notice of the court.
by way of separate,
Petition. The subsequent event is brought to the notice of the court and petition wage and really asking the trial court or the appellate court to accordingly give relief.
okay.
But
Sir,
the party should be diligent.
Yes, sir.
సార్ సబ్సిక్వెంట్ ఈవెంట్స్ ని అనేది కేసు డిస్పోజ్ అయిపోతుంది సార్. అపీల్ ఏమి ఉండకపోయినా కూడా రీఓపెన్ చేసి పడేయాలి సార్.
కేసు డిస్పోజ్ అయిన తర్వాత అప్పీల్ లేకపోయినా కూడా సంథింగ్ జరుగుతుంది అని అంటే డిపెండింగ్ ఆన్ దట్ వాట్ ది డిఫెండెంట్ హ్యాడ్ డన్ యూ హ్యావ్ టు టేక్ యాక్షన్. సపోజ్ హీ హ్యాస్ encroached into the site for which injunction is granted, then he is liable for arrest under Order 21 Rule 32 CPC.
Through EP5 subsequently.
Subsequently. So, for the subsequent event, if the executing court has got power, then it will exercise it. If there is appeal, then the appellate court will exercise it.
Okay.
Sir, one doubt, sir.
Yes.
Sir, ఇప్పుడు ఇండియా ఒక న్యూ సూట్ లో సార్ ఎవరైనా మన దగ్గరికి అపీల్ కి వచ్చిన టైంలో there might be some previous suits between them and with third parties. సో దానిలో ఉన్న మెటీరియల్ మనకు ఒక్కొక్కసారి కావాల్సి వస్తుంది సార్. కాకపోతే అప్పటికే ఆ సూట్ అయిపోయి కొన్ని ఇయర్స్ అయిపోయి రికార్డ్స్ దొరకని పరిస్థితుల్లో అప్పుడు ఏం చేయాలి సార్? అంటే దానిలో కంటిన్యూస్ గా రికార్డ్ ఉండదు కోర్టులో, లేకపోతే రికార్డు డెమాలిష్ అది
సూట్ రిజిస్టర్ ఈజ్ ఏ పర్మనెంట్ రికార్డ్ అండి. సూట్ రిజిస్టర్ లో పార్టీల పేర్లు, సూట్ దేనికి వేసింది, కాజ్ ఆఫ్ యాక్షన్, రిలీఫ్ ఏంటి, అది సూట్ ఏమైంది, ఈపీ ఏమైంది, మొత్తం అన్ని ఉంటాయి దాంట్లో. అప్పీల్ అన్ని ఉంటాయి
సార్. అంటే కొన్ని
కాపీ తీసుకోవాలి
సార్. కొన్ని సిచ్యువేషన్స్ లో ఏమవుతుందంటే సార్, ఎవరో ఇంప్లీడ్ పిటిషన్ వేసి ఉంటారు. సో ఆ ఇంప్లీడ్ పిటిషన్ డేట్ అవి రికార్డ్ లో ఉండవు సార్. అంటే అది రికార్డ్ మొత్తం ఇది చేస్తూ ఉంటారు, డిస్ట్రాయ్ చేసేసి ఉంటారు. సో ఇప్పుడు ఏంటంటే సార్, ఒక సూట్ లో డిఫెండెంట్ అందులో వన్ ఆఫ్ ది పార్టీ కాబట్టి అతనికి నాలెడ్జ్ ఉంది పర్టికులర్ ఈవెంట్ మీద అని చెప్పారు. కానీ యాక్చువల్ గా ఏంటంటే ఇంప్లీడ్ అయిన డేట్ కి సూట్ వేసిన డేట్ కి చాలా డిఫరెన్స్ ఉంది సార్. అంటే దట్ వాజ్ ఆల్మోస్ట్ 2 years అనమాట. అంటే 2 years తర్వాత ఇతనికి నాలెడ్జ్ వచ్చింది, అప్పటికి డ్యామేజ్ జరిగిపోయింది సార్. సో ఇట్లాంటి సిచ్యువేషన్స్ లో మనకి డాక్యుమెంట్ రికార్డ్ ఏమి ఉండదు సార్ దానిలో. అంటే లోవర్ కోర్ట్ రికార్డ్ కూడా వాళ్ళు డిస్ట్రాయ్ చేస్తారు. అట్లాంటి టైంలో ఏం చేయొచ్చు సార్?
అదే సార్, ఇంకా యూ హ్యావ్ టు డిపెండ్ ఆన్ ది సూట్ రిజిస్టర్ విచ్ ఈస్ ఎ పర్మనెంట్ రికార్డ్.
ఓకే,
దాంట్లో అన్ని రాస్తారు, ఇంప్లీడింగ్ అన్ని రాస్తారు.
ఓకే. అంటే కొన్ని ఏం చేస్తున్నారంటే సార్, ఇప్పుడు ఆర్డర్ 39 Rule 1 and 2 ఒక 3-4 పిటిషన్లు వేసాం అనుకోండి సార్, వాళ్ళు 39, 1 and 2 అని చెప్పేసి 3-4 పిటిషన్లు రాస్తున్నారు. కానీ దానిలో సబ్ ఏం అడిగాము, అంటే ఏ పిటిషన్లు ఏ రిలీఫ్ అడిగాము అనేవి అట్లా డీటెయిల్ గా రాయట్లేదు సార్ కొన్ని కోర్ట్స్ లో.
ఎక్కడ రాయట్లేదు?
మన సూట్ అదే రిజిస్టర్, ఐఏ రిజిస్టర్ ఉంటుంది కదా సార్,
ఐఏ
రిజిస్టర్ లో ఉండదు. మనమేమో ఐఏస్ ఉంటాయి, కానీ ఆ ఐఏ ఏంటి అనేది మనకు తెలియదు. థర్డ్ పార్టీగా మనం వెళ్ళి చూసినప్పుడు ఆ రికార్డు ఎవరు వేశారు అనేది ఉంటుంది తప్ప ఏ రిలీఫ్ కోసం వేశారు అనేది ఉండట్లేదు. దానికి సంబంధించిన ఐఏ ఆర్డర్ ఉండట్లేదు సార్. అన్ని డిస్ట్రాయ్ అయిపోయి ఉంటున్నాయి.
అంటే ఇంకా ఆ సూట్ కు సంబంధించిన సూట్ రిజిస్టర్ మీద మనం డిపెండ్
డిపెండ్ అవ్వాల్సింది, ఇంకా ఆప్షన్ ఏం లేదు సార్. సార్ నార్మల్ గా ఎన్ని రోజులు ఉంచాలి సార్ ఈ కోర్టు డిస్ట్రాయ్ చేయకుండా, అంటే యాజ్ పర్ రెగ్యులర్ ప్రొసీడ్యూర్?
అప్పీలు, సెకండ్ అప్పీల్ ఇవన్నీ ఒకవేళ ఉంటే అవన్నీ అయిన తర్వాత అది డిస్ట్రక్షన్ కొంత పీరియడ్ ఉంటుందండి. ఆ పీరియడ్ బట్టి డిస్ట్రాయ్ చేస్తారు. నేను చెప్తాను ఆ పీరియడ్ ఏంటని.
ఓకే ఓకే ఓకే, రైట్. థ్యాంక్ యూ సార్, థ్యాంక్ యూ.
Any further doubts?
అంటే పార్ట్ 1, పార్ట్ 2 అని ఉంటాయి సార్. కొన్ని ఏమో ముందుగా డిస్ట్రాయ్ చేస్తారు, కొన్ని తర్వాత డిస్ట్రాయ్ చేస్తారు.
ఓకే ఓకే సార్, ఓకే, థ్యాంక్ యూ సార్.
థ్యాంక్ యూ.
సార్ ఒక డౌట్ సార్, ఈ ప్రోనోటో సూట్ అనేది ఉంది సార్, దాంట్లో ఎట్ ద టైమ్ ఆఫ్ క్రాస్ ఎగ్జామినేషన్ అటెస్టర్ ఎవిడెన్స్ లో అతను ఈజ్ ద ఎంప్లాయ్ ఆఫ్ ది మిర్చి కమిషనర్ సార్. అతను ఇతనితోటి వేయించాడు ప్లెయింటిఫ్ గా. మిర్చి కమిషనర్ వాళ్ళ ఎంప్లాయ్ తోటి బారో చేశాడు డిఫెండెంట్ అని చెప్పేసి వేశారు సార్. అది నేను ఎట్ ద టైమ్ ఆఫ్ క్రాస్ ఎగ్జామినేషన్ కెపాసిటీ గురించి అడుగుతా ఉన్నాను సార్. హీ హ్యాస్ నో కెపాసిటీ అని చెప్తాను, మీరు ఏం చేస్తారు అని. అతని ఎంప్లాయీని అడ్మిట్ అయ్యాడు, థర్డ్ పార్టీ ఎంప్లాయీ నేను, అది మిర్చి కమిషనర్ ఇది అని. మీకు ఎర్నింగ్ కెపాసిటీ ఉందా అని అడిగితే ఉంది అన్నారు. మీ పిల్లలు ఏం చదువుతున్నారు అని అంటే నేను చదివించడం లేదండి డ్యూ టు ఫైనాన్షియల్ ఇన్కెపాసిటీ అన్నారు. లేక నేను చదివించలేదండి. అది రికార్డ్ చేయలేదు సార్ మేడం, అరే మ్యాజిస్ట్రేట్. యాక్చువల్ గా అది
గ్రౌండ్స్ ఆఫ్
అది
అప్పీల్
అది నేను అపీల్ చేసా కానీ ఇప్పుడు మీరు ఫ్యాక్ట్స్ అనేది ఇది రికార్డ్ చేయలేదు. నవ్వేసి ఆవిడ మ్యాజిస్ట్రేట్ కు సార్ న్యూ కమ్మరు
మీరు నెమ్మదిగా ఏదో ఒక గ్రౌండ్ పెట్టి రిమైండ్ అడగండి మరి.
అడగొచ్చా సార్? అదే సార్, అది పెండింగ్ ఉంది. అదే సార్ నిన్న మీరు అడిగారు అప్పీల్ ఏమైనా ఉన్నాయా అని. ఆ ఫ్యాక్ట్ రాయని ఇప్పుడు వచ్చింది సార్ నాకు నాలెడ్జ్. ఫ్యాక్ట్ అది గ్రౌండ్ గా తీసుకొని రాయొచ్చు సార్. ఇప్పుడు అడిషనల్ దీని కింద అప్పీల్ కూడా అమెండ్మెంట్ కింద ఇంకా ఇది సార్. కన్సిడరేషన్ అనేది ట్రయల్ జరిగింది ఒక ప్రిసైడింగ్ ఆఫీసర్ సార్. అట్ ద టైమ్ ఆఫ్ క్రాస్ ఎగ్జామినేషన్ అటెస్టర్ అండ్ ప్లెయింటిఫ్ ఆయన ప్లీ ఏం తీసుకున్నారని అంటే సఫిషియంట్, వాళ్ళు మీరు 20 lakhs ఇచ్చామన్నారు సార్. అది మీకు రిటర్న్స్ ఐటీ రిటర్న్స్ ఉన్నాయా మెన్షన్ చేశారా అని అంటే ఐటీ రిటర్న్స్ లో ఏం చేయలేదు అని అన్నారు. ఇంకా తర్వాత ఫర్దర్ అడగడానికి సార్ అన్నారు మీకు కావాల్సినవి వచ్చేసినాయి కదమ్మా అన్నారు. దేర్ ఆఫ్టర్ నెక్స్ట్ ప్రిసైడింగ్ ఆఫీసర్ ఆర్గ్యుమెంట్ కి వచ్చింది సార్. అది ఆర్గ్యుమెంట్ కి వచ్చేసాక దాంట్లో ఆయన జడ్జిమెంట్ చెప్తూ కన్సిడరేషన్ పాస్ అయిందా లేదా అనేది ఇష్యూ ఫ్రేమ్ చేయలేదు దీంట్లో అనుకుంటే జడ్జిమెంట్ చెప్పేసి డిక్రీ చేశారు సార్. అది అపీల్ ఇది ఉంది. అది మళ్ళీ మనం ఆ కన్సిడరేషన్ పాస్ చేశారా అనే దానికి ఏమన్నా డిమాండ్ చేసుకోవచ్చు సార్? అది హైకోర్టులో ఉంది పెండింగ్.
Please read the judgment and every piece of paper thoroughly and seek one of the reliefs that the appellate court can give with regard to remand. Yes.
Thank you.
Any further doubts? Any further doubts? Yes, sir. We will conclude, sir.
Okay.
Thank you so much, sir.
Thank you, sir.
Thank you, ma'am.